Welcome everyone. We want to welcome our participants from all over the continent, from all over the world, as we today convene to go through our third module, focusing today on, of course, engagement with our two human rights bodies, the African Court on Human and People's Rights, as well as the African Commission on Human and People's Rights. This is an online training convened by the African Court Coalition, as well as with the support of the RWI, or the Raoul Wallenberg Institute of Human Rights and Humanitarian Law. My name is Tarisai Mutangi. I am the moderator of today's session, where we are looking at inclusion of gender issues while engaging with the African Court and the African Commission on Human and People's Rights. You will recall that over the past two sessions, we have been focusing on engaging the two human rights bodies in Africa. On the first day, it was rules of procedure of these two institutions. And on the second day, we looked at the strategic engagement with the two human rights bodies, where we're looking at how to strategically engage them. And our presenters emphasized that there are several ways through which one can engage these institutions, but there is need to be strategic in that engagement. What is the outcome that you want to achieve? What is the goal, the objective of the engagement? And that's what they took us through. And we had a presenter from the Indo-American system who presented on the engagement that takes place within the Indo-American system of human rights. And we learned a few lessons, how they do it in the Americas, what inspiration we can draw from there, how they have overcome the challenges that they have met in that system. But today we continue to focus on inclusion of gender issues. And you agree with me that every aspect of engagement with the human rights bodies needs to be looked at with the gender optics. It's important whether it's litigation before these institutions. I have read around where researchers have concluded that there are few cases being filed before these institutions, for instance, dealing with gender issues and so forth and so on. Even if you look at other aspects of engagement that we look at, like implementation of decisions of these institutions, there is need to interrogate them, to analyze them with gender dimensions or gender implications, so that these issues are mainstreamed in the engagement process. Today we have two presenters to take us through this. As usual, we allow our presenters to present or to share with us their views or their ideas without interruption. Thereafter, we'll give participants an opportunity to react to the presentation by raising questions or comments, or just making a contribution to the discussion. There is no limit as to the nature of the interaction that the participants can have. So our first presenter is going to be Mr. Eric Bismana. He will take us through the first presentation. And He will be focusing on inclusion of gender issues while engaging with the African Court on Human and People's Rights. And in the second session, we will have Ms. Judy Gitau, who will take us through inclusion of gender issues while engaging with the African Commission on Human and People's Rights. Mr. Eric Bizimana is already on standby, but I'll briefly here share with you his profile, as we usually do. He's a senior legal officer at the Institute of Human Rights and Development in Africa, otherwise known as ACHPR. And this is a Pan-African organization, non-governmental organization, that works to ensure the effectiveness of human rights in Africa. And they do so through capacity building, litigation, publication, and advocacy. Our presenter, Eric, has prepared and argued a number of cases before the African Court on Human and People's Rights, the African Commission, as well as the third human rights body in Africa, the African Committee of Experts on the Rights and Welfare of the Child, as well as the ECOWAS Court of Justice. In addition, he has conducted over 30 human rights training programs for various sectors, such as judges, lawyers, and parliamentarians, and the police, among others. And he has been working on the implementation of decisions of the African Court. It's a judgment, that's case number 46 of 2016, as well as decisions of the African Commission on communications that have been filed before it, including the ECOWAS Court of Justice, where he also has been appearing to argue cases. And before joining AHRDA, he has been with the African Commission on Human and People's Rights. And in Burundi, at national level, he has assisted and represented a number of women and children who are less privileged before national courts. And he has also worked as a collaborator of the Avocats Sans Frontières. He's a member of the Bujumbura Bar Association, and of course, a counsel before the African Court on Human and People's Rights, among other professional bodies he is a member of. So, dear colleagues, here is Eric. This is our colleague here, and you can agree with me that we have a colleague among us who is familiar with engagement with the African Court on Human and People's Rights. And I personally cannot wait to hear his views on the inclusion of gender issues while engaging the African Court on Human and People's Rights. So Eric, please take the floor and take us through your presentation. And thereafter, we will pose questions to you and some comments and also contribution from the participants. Eric.
Thank you very much, Tarisai, for a comprehensive introduction. Good morning, participant, and good morning, staff of the African Court Coalition. First of all, thank you for organizing this workshop on this important topic. My name is Eric.
Kindly check on audio.
Sorry? Can you hear me, please?
Yes, you can go ahead, Eric. Please go ahead.
Thank you. Here is the outline of my presentation. I'll try to clarify the concept of gender, and then I will share with you some examples of gender issues which you may take may take for litigation in the future. Then we will discuss why it is important to engage the African Court on gender issues. And then finally, we discuss the role the court can play in monitoring implementation. First, let's talk about the concept of gender. I think the key sentence you should keep is that gender is not sex. That's something you should keep, even if you forget everything else about the concept of gender. Gender is not sex. And what is the difference? Sex refers to biological characteristics that generally define human being as male or female. And in rare instances, you may find maybe a child born with some other characteristics. But usually, generally, sex will identify a newborn child as male or female. On the other hand, gender refers to roles and the responsibilities that society attribute to persons for just being a girl or boy, or men or women. You agree with me that sex is born with, while gender is not born with. The role you play in society is not born with. You learned it through time. And then sex is natural. It's in the nature for human to have sex. But the gender roles are learned throughout time. Sex doesn't also vary from one place to another from time to time. As far as I know, people have been characterizing male and female sometimes into a third, maybe another sex, but the gender roles vary greatly. And I'm sure in your country, from the time you were a child up to now, the role associated to being a male have been changed greatly. Same thing for the role played by women or girls. And then sex cannot be changed except with medical treatment. But for gender, we know that gender roles change over time. And I think this summarizes really the difference between gender and sex. If you have any question, you can ask a question later after my presentation. So, in short, at birth, the difference between boys and the girls is their sex. As they grow up, society gives them different roles, attributes, opportunities, privileges, and the rights that in the end create the social differences between men and the women. And this translates into many aspects of our life. Now I'm going to move on to different examples of how the gender differences translate into legislation, practices, traditions, and so on.
Before you do that, Eric.
Yes.
Are you scrolling your slides? We can't see them moving. We are still on the first slide.
Oh.
Yes. So it's important that as you speak further, we also follow you as you scroll through your shared screen.
I thought I was doing it, sorry.
No,
I've been scrolling, but I don't know why.
it's not moving on the shared screen.
Ah, la, la. So how should I proceed then?
Probably you need to share the screen again.
Mhm. Let me see.
So that participants are able to follow you as you. So please share your presentation again through share screen. Let's see. Okay. So I see here the one that says the concept of gender. Is that where you are?
Yeah, yes, I was going to move to the next slide.
Mm-hmm. Can you move now? Yes. Now it's moving. Yes. Thank you. Please continue.
Okay. So I was saying that the gender translates into laws and practices. And here I'm going to give participants some example of gender issues. The difference between a man and a woman will translate to discriminatory laws and policies. Here are a few examples, and I got these examples not only from my practice, but also from the recommendation or the observation from various treaty bodies, including the CEDAW committee. In the laws, you will see, for instance, inequality in marriage. The law, for instance, say that the husband is the head of the family. Why is he the head? Why is he not on the same footing with his wife? Because of the roles society attribute to men and the woman. You can see also in the transmission of nationality, even to children. You see in some legislation that the women play a subsidiary role in transmitting nationality to their children. For instance, they only transmit nationality to their children if the father of the child is unknown or the father has denied the paternity of the child. You can see it also in divorce issues. For instance, a man can divorce his wife if the wife commits adultery. But for the wife to divorce a man for adultery, that adultery has to have an offensive character. How do you prove an offensive character? This is a subjective matter, and it will make it difficult for a woman to get divorced. These are laws that are discriminatory. But sometimes you just see discrimination in school, even in some countries, especially Muslim-dominated countries, that a woman cannot travel alone. In Egypt, a girl cannot go stay in a hotel alone. It's prohibited. He can't even go to visit his classmate without a written authorization. Otherwise, even the watchman can arrest her or report her to the police. Apart from discriminatory laws and policies, we see also de facto discrimination. And this usually affects vulnerable groups, such as children living in poverty, working children, children in a switch situation, and so on, unequal opportunities. And so sometimes you also see a silence of law. There are many countries, especially in West Africa, where FGM is very prevalent, but the law is silent. Girls undergo different abuses, but as FGM is not criminalized, as the law is silent, the perpetrators cannot be punished. You can say the same thing about marital rape, child marriage, or polygamy. Then we see patriarchal attitude and harmful practices such as child marriage, rape rate, polygamy, divorce upon simple notice, unequal inheritance right, abuse in the family, and so on. And when women do encounter those violations, sometimes they have serious challenge to have access to justice. There, I want to raise some barriers. Most women are uneducated. They live in the very traditional, very conservative areas. And whenever they face problems, they resort to customary tribunals or Sharia court, applying norms, applying customs, and the Sharia, which are not women or children friendly. And usually, the customary laws and the Sharia laws will cover issues such as marriage, adoption, inheritance, marital property, and so on. Moreover, the panel or bench in those courts are not trained to apply modern law, let alone interpret the traditional norms in the light of international standards. And then there is impunity, which is really the trivialization of abuses against a woman. For instance, a girl will report her case to a police officer, and the police officer will say, why did you wear a short skirt? So you go back home, change your skirt. Then women will be discouraged. And even if there is a prosecution, the sentence will be very light, which doesn't discourage abuses against a woman. Another example is insufficient training for judges, prosecutors, and the law enforcement officers. Probably in some of your countries, when in your undergraduate studies, probably there is no human right course at all. Or if it is there, it is optional, and they don't go into the subject seriously. So at the end of their university, judges, prosecutors, and even lawyers, they may not have enough human rights knowledge. And when they are reading the national laws, they are product of the society. They read it from the traditional perspective, and then they apply it in a way detrimental to women's rights. 6th example is the lack of registration of marriages, especially in the rural areas. In those instances, when women want to divorce, what do they get? They can't even prove that they were married. So they are compelled to stay in a very bad relationship because they have a lot of tools if they were to separate from their husband. Then there is insufficient support for victims of violence. No legal assistance, no rehabilitation service, and so on. So these are some of the examples of gender issues you may encounter in your various jurisdictions. Then why engaging in the court on addressing these issues. I will talk about 4 points. First, that the court has a broad jurisdiction to deal with gender issues. The jurisdiction of the court is defined under Article 3 of the Court Protocol. Basically, the court has jurisdiction over any cases alleging the violation of a human rights treaty ratified by the state concerned. Maybe a treaty, a regional treaty, a UN treaty, and so on. As long as it's a human rights treaty, the court is competent. And ratified by the concerned state, the court is competent. I think that gives you an idea of what issue can raise before the court. Because some of those treaties deal specifically with women's rights, and they can be used to address gender issues. You can, for instance, go to the Maputo Protocol. This protocol addresses many issues affecting women's discrimination, exploitation, the right to life, harmful practices, inheritance, and so on. I'm not going to give you all details because I'm sure you can read the protocol yourself. I want just to give you some examples to show how the protocol can be used to address gender issues before the African Court on Human and People's Rights. Can CEDAW, the Convention on the Elimination of all forms of discrimination against women. There are many progressive provisions you can rely on. The African Charter on the Rights and Welfare of the Child. And I'm sure, I don't know if people from the Anglophone countries, but in the Francophone country, usually we get training from, the trainers come from Belgium, France, or maybe from UNICEF. And as you know, UNICEF mandate is to disseminate the UNCRC, not the African Charter on the Rights and Welfare of the Child. And yet, there are many progressive provisions in the African Charter on the Rights and Welfare of the Child that you can use to advance children's rights. And in many respects, this charter is more progressive than UNCRC. So it is important to rely on it when you argue a case before the African Court. For instance, the age of marriage is clearly defined as 18 years. This is not clear. This is not clear in the UNCRC. Then, for instance, this charter protects pregnant girls in school. The UNCRC is silent. So I can give you many other examples. The African Youth Charter, the Banjul Charter, which is the African Charter on Human People's Rights, the Convention on the Right of Persons with Disabilities, and so on. Sorry, Chaisa, I don't know how much time do I still have for this presentation.
Eric, are you asking in terms of time?
Yes, yes.
Yes, you have another 15 minutes.
15, not 5. Then.
But let me know if you need a little bit more, but
Okay,
want to keep it shorter because we started late, so want to remain within our timelines. Please continue.
Okay. The Banjul Charter also contains some provisions that can help you argue gender issues. For instance, to prohibit discrimination on the basis of sex. It talks about equality before the law. You know, in the doctrine, usually we distinguish between equality before the law and equality in the law. Sometimes the law can say you are equal, but in practice, people don't become equal. Usually, then you need some other actions to make equality or equity real by some positive action in favor of disadvantaged groups such as the women or girls. It also talks about elimination of discrimination against the women, the protection of the family under Article 18. You can also find some interesting provision in the Universal Declaration of Human Rights. And interestingly, the African Court has said that the Universal Declaration has acquired the status of customary international law. Which is very unusual because a declaration is not a treaty. It's usually not binding on state. But this particular declaration has reached this status. So you can then approach the court alleging a violation of the Universal Declaration of Human Rights. And I have given you some cases where the court has affirmed the status of customary international law. At the ECOWAS court level, it has also been the case. Then you can find also some relevant provision in the ACHPR, as the International Covenant on Civil and Political Rights, as well as the International Covenant on Economic, Social, and the Cultural Rights. The third reason why we should engage the court, that the court or the commission is sometimes the only available avenue. Let's say if they exhaust the local remedies, where else can you go? Nowhere at the local level. And sometimes there is not even an avenue at the local level. For instance, in some countries, in constitutional matters, after a law comes into force, only a few authorities can challenge that law before a constitutional court. In the case of Mali, for instance, only the President of the Republic, I think a third of senators or member of parliament, and the Speaker or the President of the Senate can take case before the constitutional court. An ordinary citizen cannot do it. That means you can't, there is no remedy available to you at the local level. Or in the country coming out from conflict, they signed peace agreement to end the conflict. In some of those agreements, they give immunity to warring parties. And that immunity is a barrier to prosecution at the national level. Yeah, I just give an example of Algeria in the Communication 348. This case was brought before the African Commission, and the victims were alleging that Algeria adopted a law barring them from instituting a legal action before local court in Algeria. And that was the case. So if those kind of law exist in your country, you don't need to exhaust local remedies, which do not exist in practice. You can go directly to the court of the commission. But personally, if your country has made a declaration allowing the court to entertain individual complaint, I think you should go to the court because really, not only of the binding nature of the court decision, but also because the current the court deals with handle case more quickly than the commission. I think in the previous session, we talked about the complementarity between the court and the commission. And I don't need maybe to come back on that. But if I still have time at the end of my presentation, I can talk about it briefly. Then sometimes there is a total absence of an accurate court. Here I give an example of DRC. In an area where there is conflict, usually whenever there is a violation, there will be an operational military court to deal with the issue. The decision issued by that military court, that operational military court, are not subject to appeal. When you are losing party, you lose for all. So in that instance, in those instances, you can just appoint the commission. Then the court can order a wide range of remedies. For instance, the court can order the repeal of specific provisions, the amendment provision in the national laws. The court can order monetary reparations. The court, in one instance, I think against Tanzania, the court has ordered the release of a person who was in jail for 30 years after an unfair trial. The court can order sensitization. So in a nutshell, the court it depends on your way of convincing the court on appropriate remedies. So when you approach the court, try to frame the best remedies, a vast range of remedies that can help you address the issue at stake. Here I give you one illustration of the cases we litigated at the African court. I was a co-counsel in this case. We sued Mali for upholding laws that are incompatible with the provision of the Maputo Protocol, the CEDAW, and the African Chapter on the Right and the Rest of the Child. Why didn't we decide to lobby the government of the National Assembly? It's because our effort would have been fruitless, because the environment was very hostile. Because this law was adopted under the pressure of conservative association, Muslim organization, which put the government to remove progressive provisions. So going back to the National Assembly would have been fruitless. So going to the court was somehow the most appropriate remedies, the most appropriate avenue for us. What did we allege? We allege such a child marriage because the family code in Mali allow marriage for girls aged 16 and even below. And then we also allege that the consent to marriage in Mali is not compulsory. Why? Because most of marriage are conducted before clergymen, what they call minister du culte. And this, when you go to an imam to conduct your marriage, the imam usually will not even ask the future spouse to come. He might maybe his parent, their parent to come. Then the marriage become valid. And from the studies we got from various reports, we had that 70% of marriage were carried out by clergymen. We don't know the percentage of marriage where spouse didn't express consent. We also alleged an equal inheritance right. And the family code gives preeminence to Islamic law and the customary law in all matters of inheritance. And the Islamic law and the customary law doesn't treat women and the men, or even again the boys, on the same footing. It doesn't also treat legitimate children and the children born out of wedlock on the same footing. These are the issues raised before the African court. So the court ruled on our favor and they found all the violations we alleged, Mali responsible for the violation we alleged. Then the court ordered Mali to amend the impunity law, to harmonize its law with the international instrument, and take appropriate measure to bring an end to the violation established. Then the court asked Mali to conduct a sensitization to disseminate the Maputo Protocol through teaching, education, and sensitization in to harmonize the family code within 2 years. Let's finish with this last slide. What role can the court play in monitoring implementation? First of all, let me say that compliance with the court judgment is not an event, it's a process. So when the court adopted a decision, doesn't mean the country will just rush to implement it. It's a process. One of the means you can use to put pressure on the state is to request to go back to the court and ask the court to pronounce on the status of the implementation. The legal basis for this application will be Article 27, 30, and 31 of the Court Protocol, but also Article 1 of the Untitled Chapter. Fortunately, in the new rules of procedure, Rule 81 expressly gives to the court the competence, the jurisdiction to entertain petition relating to lack of implementation. From the interview I conducted with the staff of the court, I heard that so far the court has been following a threefold approach to implementation when it is dealing with application for non-implementation. The court can hold implementation hearings, and the court can report the lack of implementation to the African Union Executive Council, and then the court can also issue a decision noting the failure to implement. In the new rules of procedure, the court can also issue an order to ensure compliance. Maybe if the court has to give more details on what compliance means. And then, in the practice of the court, the judgment have not been really very clear. If some of you are interested in the case law of the Inter-American Court, you would realize that the Inter-American Court provided details on how states should carry out implementation. The court, for instance, if the court order a medical treatment, the court will first of all engage the party to see what are the facilities in the respondent state. How many specialists are there? how the facilities are accessible to the victim. And then what is, the court will, for instance, look at the report, the level of suffering, and say, here the expert, how long the treatment is needed. Then the court will say, for instance, state has to pay, for instance, to allow the victim to follow medical treatment in this particular facility as long as the medical attention, psychological assistance is needed. The court will also say, for instance, if the facilities are very far from the victim residence, we say, okay, the state can just pay them money for the victim to go seek medical attention elsewhere. I think it is important for us, whenever we make submission to the court, to try to give the court, to suggest solutions to the court. Tell the court, these are the facilities available in our country. This is what you can order to the state, and so on. So if I still have time, I think I can talk briefly about the relationship between the court and the commission, but if there is no time remaining, then I should thank you for your attention. Thank you.
Thank you, Eric. We really appreciate your remarks. I was following your presentation with interest. In particular, I was looking at, trying to figure out, like I said in my introductory words, I said I've read in a couple of research publications where researchers have noted with concern that even though awareness of the need to bring gender issues before our human rights bodies is very clear, the awareness is there, why is it the case that in spite of all those problems that they've listed that impede access to justice by women in Africa at least, why is it that we do not seem to see a flooding of cases being brought before the human rights bodies? What could be the reason? More and more cases should be brought before these bodies, strategically, of course, to ensure that the rights of women are promoted, they are protected in Africa, and they're effectively protected through the decision-making processes that go through or that are carried out by the African Court and the African Commission. So for me, I would like to, like someone has been working in this area for some time, and I know Judy will also want to speak on that at some point after a presentation. In the general discussion, we can talk about it to say, why is it that the number of cases that we are seeing coming to these bodies are limited in number? They are limited in number, yes.
Thank you so much. I think from my personal interaction with the lawyers who have been training over the last 5 years, I think most of them raise issues related to implementation. They say, why do I go to litigate when the judgment or the recommendation from the commission are not implemented? Because there's some, maybe NGOs can try to engage, but lawyers in those law firm, what they look at most of the time is the pecuniary aspect of the litigation. Because a lawyer, whenever he takes a case, we want to get paid from it. So if it is a private law firm, usually they say, even if I litigate, I don't get anything, so there's no need to litigate such case before the court. But also I can say that some of civil local organizations, they lack capacity. You may be surprised that someone are not even aware of the existence of this mechanism. They may not even be aware, let alone having the capacity to engage. They don't have any lawyer working in those structures. They can't bring cases. But moreover, there is a silence around gender issues. Some victims will not even want to talk about their cases before publicly. So some may be reluctant to bring cases before the court. And in some instances, you may not be able to gather the evidence to bring a case. For instance, if the violation occur in the family, how will you be able to gather the evidence? No one in the family will give you testimony because they fear possible reprisals. They will not give you the testimony. So it's very difficult to put together the evidence and to bring a case. And then I think for the African court, few states are party to the court, allow individuals to bring a case before the court. And some people will not really, they don't have possibility of bringing cases like to the court. And they go through the commission is underused, and I don't know if the new rules of procedure, if there will be a change. But I think it is important for us, civil society and also private lawyers also to try to go to approach the court via the commission. And I think that's where the complementarity between the two bodies can be useful. We know the commission deals with case from 54 countries, when the court is just dealing in case from a few countries. So I think the commission maybe in the coming years willing to transform our cases to a court. I think you can make that attempt also, try to put the commission to act, because they are there for us. They are not there for themselves. You can put them to transform our case to a court. And then I can say that for some lawyers, unfortunately, they still have some of this patriarchal mentality. For them, maybe some violations affecting women are still normal. They're acceptable. So they're not willing really to take case before, because some of these lawyers may be polygamous themselves. It may be polygamous. So he can't fight against polygamy when he's himself polygamous. I think those are some of the example I can give, some of the reasons. Thank you.
Yes, and I understand. I get the point that you are raising. And by the way, Eric, I know you're bilingual or probably multilingual. Please feel free to use any language that you feel comfortable with. To fully express yourself the way you want to express yourself, because I'm going to put another question to you, which is to say, looking at where we are as Africans at this stage, in terms of our understanding of women's rights issues, the need for them to be promoted and to be protected, do you see some particular issues that you'd say they really come to the fore? If you rank them out of 10, you'd say they're in the top 5 issues that you think probably should be brought before our human rights bodies. I know there's a huge issue of change of attitude across the continent in terms of our approach to women's rights. But here I'm talking about engaging with these 2 or 3 bodies, if you like. Are there particular issues that you'd say these should be brought before the court or before the commission as soon as yesterday? And the reasons behind that. Do you think you can react to that quickly?
Yes, the first issue that comes to my mind is FGM. Really, if you look at the statistics, especially in West Africa, so that the overwhelming majority of girls have to undergo FGM. I was really statistics for Mali when they said that 94% of girls have underwent FGM. And that's the really, if you look at the ramification of the consequences from FGM, medical, psychological, even a sexual health, reproductive health. I think this is a very important issue that we should mitigate. They probably push for the criminalization of FGM in the countries. I think that's really the most important issue that comes to my mind. For other issues, really, I don't see the hierarchy between other issues. Because really, on polygamy, I think even women themselves, they are very divided. In the past, I think 2 years ago, we were holding a workshop on women's rights in Mali. And I think some women's lawyers, they say, no, you are attacking our religious beliefs. This is not the right forum to discuss this polygamy. So I would also maybe, another idea that comes to my mind, I think child marriage. I think that's the second issue maybe that can be mitigated, child marriage. I think states should commit to raise the age of marriage to 18 years old. So those are the two issues I think that are more important to me. Thank you.
Yes, but by the way, Ruth Kihiyu agrees with you on, and the participant says, interesting remark about existing patriarchal attitudes within lawyers. I agree with this view. I mean, the view that we're sharing, to say sometimes as litigants, or as professionals, as lawyers, are supposed to assist people. We also have our own patriarchal attitudes, which then impede the way we should be advocating and pushing for the protection and promotion of women's rights or equality in Africa. And then someone in the chat box, I think it was Gender, says, has been translated by our support team. How can we fight against de facto situations that constitute an obstacle to gender equality in countries with perfect gender laws, such as the DRC? So I said the DRC has perfect gender laws, but there are de facto situations of gender inequality. How can we deal with those, in spite of the fact that the laws are there and they are in their perfect form or state, but still on the ground, de facto? As a matter of fact, gender inequality still persists. And before you respond to that, I'll give participants an opportunity to contribute. I recognize Isabel. Isabel, please make your contribution. Isabel, your hand is up. Would you like to make a contribution? Okay, I'll come back to Isabel. Let me move on to Tolmo. Yes, please go ahead.
Je me nomme Isabelle, je suis juriste de formation, membre de l'association des femmes du pouvoir. Nous avons l'habitude de traiter très souvent les questions de genre, surtout les violences basées sur le genre. Et très souvent dans nos sensibilisations, nous tombons sur des cas où les hommes se plaignent. Et ils disent que...
Isabel,
oui.
Can you speak up a bit, please?
Je disais que je suis membre de l'association des femmes juristes de Côte d'Ivoire Et nous avons très souvent, nous traitons très souvent la question du genre. Et quand nous avons nos sensibilisations, nous tombons sur des cas où les hommes se plaignent. Ils disent que concernant la question du genre, nous sommes plus basés, les gens se basent plus sur la défense des droits des femmes, alors que les hommes sont aussi victimes de cette question du genre, puisque nous savons que concernant le genre, comme le conférencier l'a dit, ce n'est pas forcément lié au sexe. Donc, les hommes aussi, il va falloir prendre en compte aussi la défense des hommes, c'est-à-dire du sexe masculin, je veux dire. Ça, c'est le premier volet de la remarque que j'ai faite que nous faisons sur le terrain, ici en Côte d'Ivoire. Et ma deuxième préoccupation concerne comment est-ce qu'en tant qu'association des femmes juristes de Côte d'Ivoire, puisque nous luttons, nous agissons très fortement dans cette question de genre, alors que la Côte d'Ivoire le gouvernement ivoirien vient de retirer l'occasion aux ONG, aux individus de saisir la Cour africaine des droits de l'homme. Donc, comment est-ce que nous, en tant qu'association des femmes de Côte d'Ivoire, on peut vous saisir? Ce sont mes deux préoccupations.
Thank you, Isabel. Tolmo, please make your contribution. Tolmo, your hand is up. Tolmo, are you there? Yes. Please go ahead, Tolmo. All right, as we wait for Tolmo, there is another question in the chat box for you, Eric. It says, in some countries, the matter of succession is still governed by custom, in spite of the ratification of the Malabo Protocol and other instruments on the subject. How could this conflict of laws be resolved in order to implement at the internal level the decisions rendered by the court? So I think the question to do with the succession being governed by custom, in spite of having their human rights instruments that that regulate the subject of succession. So the question by the participant is to say, how could this conflict of laws be resolved in order to implement at the internal level, at the national level, I think, the decisions rendered by the court. I'm trying to see if there are any other questions. Yeah, so this other question from, on DRC, you remember the conflict of laws. Not to say there are perfect laws on gender equality, but on the ground, situations of discrimination or gender inequality still persist. How can this be resolved? There's another, I think it's a comment here by Ruth. It says, I think the issues of equal rights at the workplace and affirmative action in political participation and decision-making should also be brought before the organs. So I think the participant is contributing to my question to say which issues should be brought before the organ. And I think they have made a contribution here to say equality in the workplace and affirmative action in political participation and decision-making are issues that also need to be brought before the organ. So you may also, express your views on these two issues, equality in the workplace and political participation by women. And then Maria says, can we have men raising voices for women? Given the majority of heads of states are men, can we have men raising voices for women? and given the majority of heads of state are men. So I think it's about the voice. How do we voice out equality issues? Men still dominating probably some of those prominent positions in society, such as being a head of state and things like that. So is it appropriate that it should be so? Tolmo, can you make a contribution now? I see you are unmuted.
Oui, vous m'entendez très bien. Bonjour.
Bonjour.
Yes, oui.
Vous m'entendez très bien? Merci.
Yes.
J'ai suivi avec beaucoup d'intérêt l'intervention de M. Eric Bizimana. Je le félicite pour la pertinence de sa présentation. J'ai quelques petits points. Je veux faire le commentaire et puis en faisant le commentaire, je ressors quelques préoccupations interrogatives. Le premier point, c'est qu'il parlait dans son exposé que certains procureurs en Afrique ont des perspectives traditionnelles de la question de genre, parce que ces procureurs sont très peu formés ou ne disposent pas de connaissances approfondies en la matière. Je ne partage pas totalement cet avis. Je ne suis pas obligé de partager l'avis de M. Iri en disant que dans toutes les constitutions de nos pays, ces constitutions qui reconnaissent la fonction judiciaire et juridictionnelle, dans le préambule de nos constitutions, la question de genre, la question des droits fondamentaux des personnes, cette question est formellement insérée dans les préambules des constitutions. Ce qui signifie qu'en tant que procureur, on doit appliquer la Constitution. On doit appliquer les textes internationaux qui sont domestiqués dans la Constitution de nos pays, qui les ont ratifiés. Et je ne vois pas pourquoi on dira que les procureurs ne s'intéressent pas trop à la matière. Peut-être que ce sont des formations qui ne sont pas données. Et s'il faut penser à prévoir les formations pour lutter contre l'engloutissement des capacités de certains procureurs, pas tous les procureurs. La deuxième préoccupation concerne le mariage. Quand on aborde le droit au mariage sous la forme moderne, androïdée, si vous me permettez comme ça, on pense que ce qui se passe dans nos villages, dans nos coutumes, ce n'est pas le mariage. Nous voyons qu'il y a des gens qui font ce mariage moderne avec anneaux, avec toute la formalité requise, mais ce sont des mariages qui échouent parfois lamentablement quelques jours après. Tandis que nos parents, nos mamans, nos papas qui vivent en concubinage notoire, donnant l'impression du mariage, ils vivent aussi stablement que possible. Alors, faut-il absolument copier ce que les autres font avec tout le formalisme qu'il faut pour parler de droit des femmes au mariage en cette matière? Enfin, c'est le dernier point, ça concerne le problème de saisine de la Cour africaine des droits de l'homme et des peuples ou des organes afférents concernant les questions de genre. Moi, j'ai constaté dans votre intervention que vous avez parlé des questions de peur, par exemple, ou des questions de connaissance ou de méconnaissance même des droits en la matière. Moi, j'ajouterai quelque chose, et peut-être deux choses. La première chose que j'ajouterai concerne le niveau d'acceptabilité du protocole reconnaissant la compétence de la Cour. Nous savons que si un État ne ratifie pas ce protocole concernant l'acceptation de la compétence de la Cour, il serait extrêmement difficile de soumettre des cas. Alors, quel est le raccourci? Je crois que je l'ai évoqué lors de mon dernière intervention. Quel est le raccourci à utiliser en cette matière? La deuxième chose que j'ajouterais, mis à part le travail laborieux que fait la coalition africaine des droits de l'homme et des peuples, malgré les difficultés réelles auxquelles elle est confrontée, il se trouve que au niveau de la Cour elle-même, il n'existe pas de points focaux de la Cour africaine des droits de l'homme et des peuples dans les différents États du continent. Parce que la coalition, c'est une organisation non gouvernementale. Mais la Cour elle-même, quels sont ses relais? Quels sont ses bras avancés au niveau d'Afrique pour que ce travail puisse être fait? Voilà, j'espère que je n'ai pas été extrêmement long. J'en ai l'habitude, je m'arrête là pour vous dire que ce sont mes quelques préoccupations que je voulais partager avec vous. Je vous remercie vivement.
Thank you, Tolmo. Thank you for your contributions. Ru Chidori, please, would like to make your contribution now. Ru.
Thank you very much, Dr. Tarisai, and thank you very much to the presenter for such a insightful presentation. My question is, so far, what has been the African Court's position in respect of LGBTI and gender non-conforming persons, noting that it is important that the African Court advance and protect through its norm-setting processes the principles and values of inclusivity and intersectionality, particularly the rights of gender non-conforming persons who are extremely vulnerable to human rights violations in many African countries. So I really want to know what is the position of the African Court in this regard. Thank you.
Thank you, Ru, for your contribution. Let me, Eric, just give you the last list of questions here, and you can react to them now, or you might, share of some of them, and then respond to them in the very last part of our program, which is the general discussion, where both of you, both presenters will be able to take up questions and comments and react to them. But here's one that says, it's from A. Maria. How can we effectively protect women's rights if the Maputo Protocol is not domesticated to the anticipated speed? How can we effectively protect women's rights if the Maputo Protocol is not domesticated to the anticipated speed? And the second part of the question says, what would be a reason for delays in the domestication of the Maputo Protocol? So I think the question, really touches on domestication of the Maputo Protocol. Why is it not moving fast? What are the reasons behind the slow domestication of the Maputo Protocol? And that probably also affects the implementation or the effective protection of women's rights. Do I see another one? Yes, there's another one from Fidel Mutoni. It says, Eric, what do you think can be a better way to strategically litigate before the African Court for the non-binary gender identity issue? For example, the issue of transgender and intersex, considering the fact that many African countries are yet to recognize it. What would be the better way to litigate strategically? We said this online training is about strategic engagement with our human rights bodies. So these are particular issues that the participants are raising to say, how can we strategically engage our institutions with these issues some of which have not really, received universal acceptance by many African countries. Their authorities not recognize them, but how can we still nevertheless be able to engage our institutions? I'll stop there, but participants can keep on putting in their questions in the chat box. At the end, in our general discussion, we should be able to get some time for Eric and Judy to respond to some of the questions. Please, would you like Eric to respond to some of these questions?
Yes, please. To be fair to my Francophone colleagues, I want to speak in French now.
Please, go on. I knew you would.
Ok, merci beaucoup. La première question concernant, je pense, provenant de quelqu'un de la RDC, c'est qu'est-ce qu'on peut faire lorsque les lois sont visiblement impeccables? Comment est-ce qu'on peut lutter contre la discrimination de fait? Donc, je peux vous donner juste ma réflexion sur ce point. Je pense que le changement d'attitude n'est pas instantané. Ça prend beaucoup de temps. Mais le fait juste d'avoir de bonnes lois en place, ça peut servir comme outil de changement. Petit à petit, je pense que ça peut contribuer à faire évoluer les mentalités. Mais je pense qu'en plus du contentieux, vous pouvez recourir à des activités de sensibilisation. Parler directement avec la population concernée. Les structures de base, les associations au niveau collinaire, et ainsi de suite. Le problème, je pense que nous avons, c'est qu'il y a une forme d'élite qui travaille à partir des capitales politiques, mais qui ne sont pas présents sur le terrain. Et quand on parle des questions genre, des questions d'égalité, des questions de non-discrimination, généralement, la population, le citoyen lambda n'est pas impliqué. C'est pourquoi les attitudes patriarcales continuent de persister dans les milieux éloignés qui sont presque coupés même du droit moderne. Il y a quelqu'un qui parle du dualisme juridique. Il y a un dualisme juridique dans nos pays. Peut-être même plus qu'un dualisme. Peut-être il y a plusieurs régimes juridiques qui s'appliquent. Tu vas trouver que dans certains coins, le droit qui s'applique, ce n'est pas le droit qui est consacré par la Constitution, par les normes que vous connaissez chez vous. La plupart des conflits sont résolus au moyen des coutumes locales. Voilà, c'était juste ma réflexion. Et concernant les personnes qui se plaignent, les hommes qui se plaignent, oui, je pense que les hommes peuvent aussi être victimes de discrimination ou d'abus basés sur le genre. Je pense qu'il ne faut pas oublier non plus que les hommes peuvent être victimes, mais à l'état actuel des choses, ce sont le sexe féminin, les femmes et les filles qui sont en grande majorité victimes d'abus de discrimination. Mais on ne peut pas ignorer non plus qu'il y a une discrimination dont les hommes sont victimes. Madame Colonel de la Côte d'Ivoire posait la question comment saisir la Cour africaine, étant donné que la Côte d'Ivoire a retiré sa déclaration. D'abord, le retrait n'entrera en vigueur qu'une année après la notification du retrait. Et je pense que le retrait n'est pas encore entré en vigueur. À l'instant, vous pouvez toujours saisir la Cour africaine. Donc, il faudra vérifier, je n'ai pas la date en mémoire, mais si vous vérifiez la date de notification, je pense que probablement jusqu'à la fin de l'année, vous serez toujours en mesure d'intenter une action devant la Cour africaine. Mais à expiration d'une année après notification, vous n'aurez plus le droit de saisir directement la Cour africaine. Pour le moment, vous pouvez saisir la Cour, mais directement à la Cour, mais après l'expiration d'une année, au courant de la notification, vous ne serez plus en mesure de le faire. Répondant à une question dans, je pense, de qui? Dr. Mo. Quand il n'est plus possible de se dire directement à la Cour, il est possible de le faire directement, de le faire indirectement via la Commission africaine. Mais il faut que l'État concerné ait ratifié le protocole établissant la Cour africaine. Si l'État n'a pas ratifié le protocole, c'est impossible d'aller à la Cour. Puisque c'est le protocole qui donne des compétences à la Cour à l'égard de l'État concerné. Dans ce cas, vous ne pouvez aller devant la Cour africaine. Ou si l'affaire concerne un enfant, vous pouvez aller devant le comité africain d'expression des droits et le bien-être de l'enfant. Soit réservé de réviser que l'État a ratifié la Charte africaine des droits du bien-être de l'enfant. Quelqu'un a posé la question du conflit de loi. Parce que certaines matières sont régies par les coutumes, d'autres matières sont régies par le droit moderne. Et que faut-il faire? Vous savez, ces questions au niveau local sont des questions très politisées. Il y a des groupes traditionnels très influents. Et si les politiques les frustrent, ils risquent de ne pas être réélus. Mais nous nous basons sur quoi? Quand vous regardez votre constitution, au moins dans la plupart des pays francophones, il est dit clairement que la Constitution, les textes internationaux ratifiés ont valeur constitutionnelle. Et nous savons que dans la hiérarchie de normes dans nos droits internes, la Constitution est au top. Donc, en principe, toute la coutume ainsi que les lois doivent se conformer à la Constitution. Je pense qu'on peut même aller devant notre Cour constitutionnelle où notre juridiction interne est compétente en matière qui peuvent juger des droits de l'homme pour dire telle coutume n'est plus valide parce qu'il viole la Constitution. La Constitution consacre le principe d'égalité entre hommes et femmes, par exemple. C'est quelque chose qui est faisable. Et quand vous regardez l'affaire de l'illustration que j'ai donnée contre le Mali, on s'attaquait en principe aux coutumes, puisque le code des personnes et de la famille est renvoyé à la coutume en matière de succession. Si la matière n'est pas régie par le droit moderne, vous pouvez saisir la Cour pour dire voilà, il faut que cette matière soit réglementée. Il faut que telle question soit réglementée dans le code des personnes et de la famille, et ainsi de suite. Je pense que si ce n'est pas possible de le résoudre au niveau interne, au niveau de la Cour, de la Commission, veut dire que l'État est en violation de ses engagements internationaux et la Cour, la Commission peut ordonner à l'État de changer sa législation interne. Et la hiérarchie me met des normes internes. Les coutumes évoluent. On connaît des coutumes qui ont disparu dans nos pays. C'est pas, comme je le disais, c'est pas un changement qui s'effectue en une journée, une semaine ou une année. C'est un combat continu. Oui, la question de contentieux le contentieux peut être utilisé pour avancer plusieurs autres causes, y compris la participation politique, l'égalité en matière de travail, le paiement égal pour un travail égal, salaire égal pour le travail de même valeur. Il y a quelqu'un qui parlait de est-ce que les hommes peuvent aussi plaider pour les droits des femmes? On est en train de le faire, nous sommes des hommes. On est déjà en train de le faire. Il y en a qui le font. Et je pense que la tendance est bonne et les hommes continuent. Les hommes qui plaident pour les droits des femmes croient de plus en plus en nombre. Et Sormo n'était pas d'accord avec moi qu'il y a des procureurs qui n'ont pas la formation suffisante en matière des droits de l'homme. Bon, on ne peut pas généraliser cette observation. Moi non plus, je n'avais pas l'intention de dire que tous les profils ne sont pas bien formés. C'est juste pour dire que notre curriculum académique ne nous prépare pas nécessairement à affronter ces questions dans la pratique judiciaire. Oui, les droits peuvent être consacrés par la Constitution. La Constitution peut faire expressément référence au traité, mais cela ne veut pas dire qu'en pratique, tout avocat va nécessairement se pencher là-dessus. Nous avons plusieurs cas dans notre pratique. Je pense que certains participants peuvent témoigner sur ce point. Et si dans votre pays, ça va mieux, on ne peut que s'en féliciter.
Eric,
Voilà, je pense que j'ai répondu. Bon, il y a quelque chose qui reste, je pense peut-être on peut y répondre plus tard.
okay. Yes, yes. I wanted actually to say you could pause here so that you can catch your breath and probably have a glass of water as we take a break now. Just a 5-minute break so that we remain within our time. So thank you so much, Eric, for the presentation, and thank you for reacting to the questions that have been put to you by the participants and comments that have come from participants as well. But like I said, our program allows you to come back again, because I've already seen their questions in the chat box anyway. So you definitely have to come back at the end after Judy's presentation, where you share the floor with Judy just to respond. I'm sure that definitely some of these issues, you know, Judy will have also some views to share, you know, looking at a profile and also looking at the organization she works for, you know, focusing specifically on equality in Africa. I definitely should have some views. So I think it would be much more interesting to then have you come back after the break. I mean, after Judy's presentation in our general discussion. So, colleagues, and gentlemen, let's take a 5-minute break. Just about 5 minutes. Let's convene at 13:50 Arusha time. So just over 5 minutes. 13:50, 1:50 Arusha time. And at that point, we'll be listening to Judy to take us through a presentation. And thereafter, we will also put questions and comments to her, and then move on to our final segment of the day, which is a general discussion where Eric can also come back to respond to some of the questions that I'm already seeing in the chat box, and that will be raised by participants after Judy's presentation. So let's take that break until 13:50 Arusha time, and we continue from there. Thank you. See you later. To take us through the second presentation on engaging or inclusion of gender issues while engaging the African Commission on Human People's Rights. I will summarize Judy's rich CV and curriculum. She's currently the regional coordinator at for Africa at Equality Now, but previously she consulted with Equality Now, the Africa office, specifically working on the domestication and implementation of African Union instruments in Africa on the rights of women. So already I can see some questions which you posed to Eric. Judy definitely has something to say about them. She has previously worked as a technical advisor on transitional justice for a justice sector development project in post-conflict Somaliland, specializing in access to justice for victims of sexual and gender-based violence. Judy has also worked as a program officer with the Kenyan section of the International Commission of Jurists. And there she was managing projects that promoted accountability through protection of international crimes in Kenya and the East African region, that is Rwanda, Burundi, Uganda, Tanzania, and Sudan. And some of the key achievements include being part of Equality Now's core team in filing a suit against the Sierra Leonean government at the ECOWAS Court of Justice. And the reason for the lawsuit was that the Sierra Leonean government denied pregnant schoolgirls the right to education. And Judy has also is a published author in the field of transitional justice and international criminal law. Above all, she is an advocate of the High Court of Kenya and a member of the Kenyan Chartered Institute of Arbitrators. And she read law at the University of Nairobi and mastered, although I feel a master's degree is gender insensitive. You know, I think there's need for a new name for this master's. You know, why should it be called a master's? I think we need a neutral name. Nevertheless, for now, I'd say she mastered in international human rights law at the University of Oxford. So this is our colleague Judy. You can see I'm reading a CV with interest. She's a colleague of mine, and I can't wait to hear her views on the inclusion of gender issues when engaging the African Commission on Human and People's Rights. So Judy, it's your time now. Let's hear your ideas, and thereafter we'll interact with the participants. Thank you.
Thank you, Dr. Teresa, and thank you, my fellow colleagues and those who have joined us today for this discussion. It's tricky to go after such a brilliant presentation by Eric, but I'll try, because at least the area I speak of is the Commission, and so I should be able to do some contrasting. Allow me to share my screen so that you would be able to follow my presentation as I start. So just a minute. Okay. I hope everybody can see that. All right.
Yes, we can see that. Please go ahead.
So I will follow Eric's, shall we say, pedagogy, in which he indicated how it is he's going to present. And I try to make it a mixed bag, because I know that those who've joined us today some are from academia, some litigate, some are practitioners in terms of the civil society field. And so I was trying to make sure that someone has something small to take out from the entire presentation, and I hope I'll be successful at the end of it. And so the presentation will have 6 parts. The first is I'll tell us a bit about the African Commission so that we know what we're talking about in terms of a platform of accountability or enforcement of law. And then the second bit of it, I will speak about the status of inclusion of gender issues at the Commission. And I'll do that by speaking about the normative framework that exists in the continent and the normative framework that lends itself to the Commission, and then contrast that with the status of women's rights in Africa. My third point is then to speak about the opportunities that portend for us to engage with the Commission, because I hope that after today's discussion, all, if at least not some of you, will engage with the Commission after that. And then I'll go through the boring, rigorous process of talking about the methodology or procedure through which you could engage in the court, and finish off on a slightly exciting note of talking about the politics that are currently at play with regards to engagement with the Commission. And I hope that will be in order. And I hope also time allows me to do that, because I know time has far gone. So what is the African Commission on Human and People's Rights? Usually when I say that, I almost want to explain why human and people, but I'm assuming that we are engaging with those of you who've already engaged with African human rights systems. But just a quick distinction, human rights are individualized rights versus people rights are group rights. And so I'm sure all of you would be able to relate with that. And even as we discuss this in the context of women's rights, you'd be able to engage with that notion. So the African Commission on Human and People's Rights is a quasi-judicial body, treaty body created under the Charter, and it was established in Addis Ababa, Ethiopia, and so serves with its secretariat in Banjul, where the different ways in which one can engage with the Commission, and I'll speak to a bit later, is usually largely done. Just bear with me as I explain what is the makeup of the commission. So it consists of 11 commissioners, all of whom are elected by heads of state and government and serve 2-year terms, all of which are a maximum 2 6-year terms. So amongst themselves, the commissioners select a bureau because the commissioners are not permanent, and so there's need for them to be able to operate and address cases. And it's important for you to note this because much later you'll see when we talk about some of the challenges this will arise. The commissioners are not permanent, and so they establish a bureau which consists of the chairperson and the vice chair, who are elected, and this serves largely serves the purpose of providing guidance and functional decisions for purposes of the commission. Then if we are to move on a little bit further, the promotion of what the mandate what's the mandate of the commission? I see it as 3 mandates, although incidentally, just before this presentation, we were having an argument with a colleague who sees it as 2. And so we will vote on this at the end. So there's a promotion of human rights, human and people's rights. And this, just as the name suggests, promoting includes sensitization, public mobilization, information and dissemination, missions, and so on and so forth, to get countries and indeed citizens of Africa to know about the Commission and to engage with the Commission. They also have a mandate, a protective mandate, and this is where most of today's presentation will dwell. And this is the mandate to protect human and people's rights. And I will speak again in detail about the communication then that is given to the Commission in order to activate this particular protective mandate, although it can play also using different mechanisms as well. And then the third mandate is the interpretation of the Charter. And so this is where we were having the argument, because ideally the court serves the role of interpreting the Charter. But could I pose perhaps a question which later you'll come back to me, maybe on chat and talk about, which is when the Commission, for example, propounds on articles of the African Charter and explains how they should be interpreted. For example, it has done that for Article 14, I think Part C it is, of 3C of the Maputo Protocol, saying this is how it should be interpreted, this is how it should be applied. Is that not the interpretive charter, a mandate of interpretive aspect of it, but the interpretation and expounding people sense it as a part of the promotional mandate. And so you could say that it has a dual mandate, which is promotion and protection. And if you are courageous, you could say it has a tripartite mandate, which is promotion of human and people's rights, protection of human and people's rights, and then interpretation of the charter. Remember, we will dwell in the protection of human and people's rights in today's presentation. So I've already alluded to some of this, which is how is this tripartite mandate fulfilled? And so it's through communication, which is most of what our discourse will be about, basically filing of complaints, human rights violation complaints before the Commission. It's in state reporting, either in Article 62 of the Charter or 26 of the Maputo Protocol. And this speaks about the obligation of states to give periodic reports on their state of compliance with the Charter and the Protocol. Just for a fun fact in there, if you are a practitioner, a civil society actor, you can be involved in the development of shadow reports to those of the state. And so this provides a very interesting avenue, again, through which states can be held accountable within the protective element as well. There's the special mechanisms, such as the Office of the Rapporteurs. So various commissioners serve as rapporteurs for special issues. For purposes of our discussion today, this includes on women's rights, and so commissioners have special rapporteur positions, and they can address women's rights. There's missions, just as it sounds. These are visits to countries and there can be protective missions. By this, I mean it can be done within the context of a communication. So if someone has filed a complaint against a state or several complaints against a state, then the commission can then pay a visit to that state to establish the facts of the issue. If some of you are familiar with the Ken Saro-Wiwa case, the Nigerian Ken Saro-Wiwa case, in that instant, the commission actually did pay a visit to Nigeria to establish the facts on the ground. And then there's a promotional mission where it gets the citizens of a country to be able to engage with a charter and to know what rights are provided and ways through which they can engage with the commission. And more recently, if I'm to speak to that, I would say that the commission actually in December last year paid a visit to Sudan, would you believe it, with regards to the Maputo protocol, which is a favorite of mine and which I will dwell on heavily as we move through. But not to forget that the commission can also provide resolutions, guidelines, and general comments. And as I've mentioned a little bit earlier, and I'm hoping I'm not losing anybody as I progress, and if I am, please just put it in the chat and I'll slow down or explain deeply. General comments include, for example, making clarity, doing an expansion on the norms, providing clarity and understanding on those particular issues. Right. Okay.
Yes, Judy, like you mentioned, just take it slowly so that the interpreters are also able to follow. Otherwise,
it'll be too fast. Absolutely.
Yeah, not much.
Oh,
yeah. Just
all right. I will slow it down. Okay. And so, as I've indicated a bit earlier, we will dwell in the communications aspect. And communications, as I've said earlier, are complaints, and it's one of the mechanisms employed by the Commission to ensure that states actually comply with the human rights enshrined in the Charter and, for our discussion, enshrined in the Maputo Protocol. And so the Commission may receive complaints either from one state against another state. And here, let me just say, only one case has ever been entered from one state against another state, unless something has happened quickly in the recent past. That was DRC versus 3 other countries. And there's also against a state, an individual's complaint against a state. Let me just allow us to marinate there a little bit, because this is actually where the court and the commission are distinct. I know Eric spoke about the restrictions with regards to engaging with the court, that countries have to have done a declaration, that those filing a case before the court must have status before the commission. But here, virtually, and I guess I'm preempting what I will say again later, but it bears being reiterated. Virtually, anyone whose country has ratified the African Charter. And somebody did ask during Eric's presentation, what happens to countries that haven't ratified the Maputo Protocol? So here's your window. Virtually any country that has ratified the African Charter, an individual in that country whose rights have been violated can file a communication before the commission. And so that is something that we need to grasp as we look ahead at the opportunities that portend. So just again, bringing complaints before the commission, as I said, is part of the protective mandate of the commission, and the charter provides in great detail guidelines of how one would bring the communication, I say litigation, but the communication before the commission, and it does so between Articles 55 and 59. The commission also adopts rules regularly. Most recently, there's a 2020 guidelines which Sophia so graciously shared with all of us as soon as they were out, and I think applicable as of September this year. So the rules are adopted in line with Article 42.2 of the Charter, which assist or just make more clear, more apparent the process and procedure and guidelines on how any of us whose countries have ratified the Charter can actually bring a complaint where their rights have been violated before the Commission. Again, just protective, just again, consider this is the same thing I've already talked about. The protective mandate of the African Commission is mainly exercised through that, interstate and individual communications. And such communications are primarily an allegation of human rights violations, although it should be noted that the African Commission's mandate is broad, subject matter mandate is broad. Currently, over 400 individual communications have been filed since the Commission was established in 1987. Let's hope that the rest of you will join form and file on a gender-specific issue, on a women's rights issue. I mean, I know Eric has already distinguished between gender as a social construct and sex, and so I will not belabor that point. The part 2 of my presentation, in which I phrased it as the justification or establishment, let me say the status of the Commission's engagement on gender issues, is again broken into 2, like I said, which speaks to the normative framework, the laws which the Commission engage in, and also the laws on women's rights as ratified and adopted by majority of the African countries, and then look at that vis-a-vis the status of women or women's rights in Africa. So the African Commission and its human rights mechanisms have adopted binding agreements, numerous measures, and produced recommendations and reports addressing the human rights of women. I actually find that an oxymoron, human rights of women, as though women would have other rights other than human, but let me just say the rights of women. And these include the following. So, of course, we begin with the African Charter. I will throw in here, though, that do you know the Charter only had one article, is it 18.3, that distinctly talked about women, and even so, it talked about in the context of the family. And so let me not start us on a limb, because I'm hoping to boost our engagement with regards to the Charter. But then you now see the need, or the reason why there was need for a protocol to the African Charter, specifically on the rights of women. And so we have the African Charter itself, which provides again for women's rights. As I said, 18.3. We have the protocol to the African Charter on Human and People's Rights. I will again go in great length to explain some of the distinct provisions that are in the African, in the protocol. Please allow me to refer to it as the Maputo Protocol. Moving forward, we have the convention governing the specific aspects of refugee problems in Africa. We have the African Charter on the rights and welfare of the child. We have the protocol on the statute of the African Court of Justice and Human Rights, although, you know, not so much will we dwell there. Additionally, we have the African Union Solemn Declaration on Gender Equality in Africa. We have the African Union Gender Policy and Agenda 2063. So I didn't just dwell in what can be used to engage with the Commission. I also just addressed the framework, the status with regards to the framework of norms that are available to protect women, and should they be enforced to ensure the realization of women's rights. And so you can see there's quite a list. Sorry, do I need to slow down again? All right, I think we're together. There's also the regions, from the ECOWAS region to SADC, having their own protocols with regards to women's rights. I will also mention the global ones, only because, as you will see later, and as I will mention, and since a whole lot of you are litigate, it'll give you a window or maybe strategy on how you could use, you know, if it's persuasive arguments or persuasive decisions, and soft law, to convince the Commission to address the issues very broadly and structurally when these issues are brought before the Commission. And so some of the things that we need to take note of include CEDAW. I know all of us are familiar with CEDAW, the Convention on Elimination of Discrimination, all discrimination against women. ACHPR, that's the International Convention on Economic, Social, Cultural Rights. the ICCPR, that's the International Convention on Civil Political Rights, the CRC, that's on the rights of the child, the Convention Against Torture, the Convention on Elimination of Racial Discrimination, the Convention on the Protection of the Rights of Migrant Workers and members of their families, and the Protocol to prevent and suppress and punish trafficking in persons. And so a lot of our African countries have actually domesticated, and where they're, for example, and allow me just to stay here just for half a second. If countries are monist, it means if they've ratified these documents, then these instruments are part of national laws, and these countries are bound by them. And if there's a further stage of domestication, then that needs to have taken place. But these instruments, to a great extent, are available to influence some of the decisions of the Commission, and even further, the decisions by the treaty monitoring bodies that enforce these instruments, the recommendations, for example, by CEDAW, the general comments by CEDAW, all of these can be used to persuade and to guide the Commission in coming to a decision that ensures the rights of women are actually realized. I hope we're together so far. And so I think I've already gone ahead of myself in speaking to what it is that I've written. Just saying communications alleging violations of right may be brought before the African Commission for any alleged breaches of the provisions of the African Charter and the African Women's Protocol and other relevant human instruments which may be invoked based on Articles 18.3, 60, and 61 of the African Charter. And so I invite us after this as an exercise to just look at the African Charter. Please look at Article 18.3, 60, and 61 and see what is available to the Commission on the same. And the note that I had written here at the bottom with regards to treaty monitoring bodies is what I was saying, that some of the materials, including from the Inter-American Court, including from CEDAW Committee, are available to persuade, to guide the Commission in making our submissions. But then we'll come down there when we're doing the more laborious part of how do you then put in our communication before the Commission. And I hope we're together there. Again, just a quick note or a fun fact is that Article 26 of Maputo Protocol installs the African Commission as the treaty monitoring body responsible for monitoring and ensuring that state parties implement the protocol primarily through state reporting, but accordingly, complaints based on the protocol will therefore be directed also to the Commission. And so it's on this basis that you'll find people will submit also complaints based on the violations based on the Maputo Protocol. So just as we pause there, you could see that the legal framework is robust. It is indeed robust. And when I will further go down and just list for you some of the firsts that the Maputo Protocol does with regards to harmful practices, with regards to structural remedies, and some of these things that I will speak to in particular detail a little bit later, then you would expect that the rights of the African woman are, there's gender parity, there's equality, we're fine, women are okay. So is this the case? And so my second part of the second part of the presentation. So despite this robust framework, 1 in 3 women in our continent have experienced either physical and or sexual intimate partner violence or sexual violence by a non-partner at some point in their lifetime. This is as bad as if we were to sample the participants and panelists, every third of us who are women would be able to resound with this particular provision, which is incredibly sad. And then in 6 countries, and this for me is where you have 6 countries, legal protection for women against domestic violence. No legal protection, but the law actually sanctions domestic violence, and I will illustrate that. The other key thing is African women and girls account for 62% of all global deaths from preventable causes related to pregnancy and childbirth. in 2020, when we are inventing, shall we say, COVID vaccines, we still have more than half of the women, their deaths are being caused by pregnancy and childbirth. In sub-Saharan Africa, women comprise the highest percentage of new HIV infection. And then what I didn't write here is that of these numbers, the majority are young women. So that's youth. Globally, an estimated 130 million girls and women alive today have undergone FGM. And a bulk of this 130 million are in Africa. 125 million, and again, you contrast this with the norms, because I've stated the norms as the norms, but haven't dived deep into the specific provisions of the norms. And I will do that when I speak to the opportunities, because I'd like you to see the data or the statistics that I'm giving as opportunities representative in each of your countries of potential communications. And if you're part of the countries that have made the declaration within the court, as potential cases that can be brought before the court. 125 million African women and girls alive today were married before 18. They were married as children. Protection, marriage, family relations, personal laws, there's a problem there. There's also non-recognition of intersectionality. We view women in a very specific lens. And so I cannot, for instance, if a girl has been banned from accessing education, we see that as the right of education having been denied. We do not see the factor that she's also been discriminated against because, for example, the right to education is as a result of her being pregnant, and only girls can be pregnant. And so there's an element of discrimination in that, and we fail to recognize the intersectionality of discrimination that sometimes, or of violations that are visited upon a group of women from time to time. And then just to note that in many of these countries, a lot of this is compounded by political instability and conflict. So I'll give you just 3 examples. Let's take this home. This as the last I checked, and participants from these countries, please feel free to come back and tell me if there's been review in laws. But Section 55 of the Penal Code in Nigeria, I just want us to look at Part D. Let's read the operating clause and then look at Part D. Nothing is an offense which does not amount to the infliction of grievous hurt upon any person, which is done by a husband for the purpose of correcting his wife. Such husband and wife being subject to any native law or customs in which such correction is recognized as law. Just letting you know, domestic violence in some context is not only an absence of protection in law, but the law actually does sanction such practice. A second example, which I'm particularly familiar with because we were working as an organization on a case in Sudan where a young girl of 17 at the time had that intersectionality visited on her. And so allow me just to say that Muslim personal law, a virgin, pubescent woman has her, let me just read it as is. The marriage of a pubescent woman shall be concluded by her guardian, with her permission and consent to the husband and the dowry. Her word regarding her attainment of pubescence shall be conclusive unless it contradicts the obvious. I'm here to tell you that the girls who get married, the consent is done either by their fathers, their brothers, or their uncles, and that consent is presumed upon them. And so this is the status of people being married as pubescents, being minors who we say are incapable of engaging in a contract legally, but are therefore capable of having a different actor, a guardian, and have them married off as children. This, when we have Maputo Protocol, this, when we have the African Charter, this, when we have CEDAW, this, when we have all the laws that I've listed for us. The final example is Section 13, and I know that there was a judgment last year that declared this particular provision unconstitutional, but I think it's important for us to know again, it was 2019, until 2019, Section 13 of the Law of Marriage Act of Tanzania provided that no person shall marry who, being male, has not attained the apparent age of 18, or being female, has not attained the apparent age of 15. Why the discrepancy? Why would the boy be allowed to reach the age of 18, but the girl 15? And then here for me is the stinker, right? Look at the penal code at 138. Any person who, being married to a girl under the age of 12 years, has or attempts to have carnal knowledge of the girl, this girl is 12. You've married her outside of even your own provisions of 15. Any person who, being married to a girl under the age of 12 years, has or attempts to have carnal knowledge of the girl, whether with or without her consent. I mean, I wish this was a physical classroom, because I would say without her consent would be, and I'm sure you would say rape, before she has attained the age of 12 years, is guilty of a misdemeanor. Those of you who are lawyers in this as participants, this is not a felony. This is a slap on the wrist. And this is the law as currently stands. And I'm happy to be corrected by participants or to be contradicted. So what has been the interaction then between the Commission and gender as an issue? Remember, you can, any one of you can file a communication, because that's where we could, on the missions, we could dwell on the shadow reporting, we could do any of those with regards to that. But because we're doing a contrast between the Commission and the court, I think it's important then that we dwell on the communication aspect. And so, again, if this was a physical class, I would say, in view of the cases, the obvious cases, and I've not mentioned any others, for example, social economic, in terms of property, in terms of women being able to own property, in terms of sexual and reproductive health and rights, all of the other issues. I haven't even given illustrations of those. But to say, in view of that, and the open door that the Commission provides, how interactive is that engagement? Only two. So one more from the court only has one, so the Commission has two. There's only been two decisions coming out of the Commission that address specifically gender as an issue. Although I have to note that the Commission is increasingly playing a significant role in enforcing women's rights. And so I don't know about my time, but let me just quickly highlight the two cases, the two complaints that were filed. One of them, I'm proud to say, was a collaboration between my institution, which is Equality Now, and Ethiopian Women Lawyers Association versus the Federal Republic of Ethiopia, where a little girl, a minor, was abducted and forced by a man into marriage. So he raped her. She escaped. He was charged. He got out on bail. He again abducted her and he married her, therefore the engagement was legal. And the Commission was seized of this matter, and it was held that the failure by the Ethiopian government to put in place mechanisms to prevent abduction and rape of a minor and investigate and punish those responsible for the offense amounted to violation of state obligations under the African Charter on Human and People's Rights, specifically integrity of the person, dignity, liberty, and security of person. And it ordered compensation to be paid to Nagash, who was a young girl. And so there were several other orders or remedies that the Commission ordered on that particular case. The second case is the case of Egyptian Initiative for Personal Rights and Inter-Rights versus Egypt, again filed before the Commission in 2011. In this case, some women were taking part in some protests, civil protests within Egypt, and they were whipped, including by the police and other civilians. They were sexually assaulted, they were harassed, they were harangued, and they were called all manner of names, including sluts and so on and so forth. And so the matter was brought. Of course, they couldn't find accountability within the country, let alone their complaints before the police to be taken in. It was taken in as a misdemeanor, so complaints weren't even registered, and so on and so forth. And the commission found that the state was in violation of Articles 2, this is right to be free from discrimination, Article 3, equality before the law, 18.3, elimination of discrimination against women, 16.1, right to health of the African Charter, amongst others. And this is the most amazing part. And someone asked just before I started, like, what happens if the government hasn't ratified the protocol? The commission actually followed principles that are already provided in the protocol, in the spirit of the protocol, but it also urged Egypt to ratify the Maputo protocol, which I thought was a very, very progressive decision indeed. So why are the cases so few, despite there being the opportunity? There are several reasons. I mean, I would say we would need to build capacity. We would need to get lawyers and citizens to understand their rights, to understand the open opportunity. But some of the more structural reasons would be that the commission convenes or meets only twice a year. And with some of the challenges that I've listed, that many twice a year hardly suffices to give attention to the cases and the issues that could possibly come before the commission. But then we also, the few meetings also means a delay in the delivery of the decisions of the commissions. And sometimes the commission takes a very long time before providing decisions from the communications that have been brought before it. There's been instances where they've done relatively fast turnaround, but that's the exception rather than the rule. The decisions and recommendations of the commission are viewed as not being legally binding. So when you do forum shopping, or when you're looking for where you could bring a case or a matter to ensure you get the most success, then people view that the decisions from the commission are not binding, and there's very little action to be taken to enforce those decisions if a government fails to implement that decision. But that's a view, because once a country has signed and ratified and domesticated and is party to the charter, really, they are bound by it according to various conventions, the Vienna Convention on the Law of Treaties, Pacta sunt servanda. I mean, the different principles that provide that you're bound and therefore cannot go and undermine the spirit and the letter of the charter. And then again, I reiterate, there's a very, very narrow interpretation of women's rights and a failure to recognize the intersectionality, and therefore people miss the opportunity to bring critical matters before the commission. Allow me to say, even as I say that, just to say, if any of us can file in contradistinction to the court, then the onus is on us then to bring matters before the commission. So despite this, what are the opportunities that portend? Sorry, let me just ask Dr. Tarisai, am I okay in time?
Judy, you're not so okay in time, because we need to have wrapped up the entire program in the next 27 minutes.
Okay,
so,
I will rush right through. So
maybe I'll give you another
10 minutes.
10 minutes, so that we have about 20 or so minutes for the final discussion. Is that okay?
Okay, so I'll dwell quickly then on what the opportunities, and just quickly tease out the procedure, but I'll be very quick then.
All right.
Okay, so again, the opportunities circulate around three main points, which I've already said. Virtually any citizen whose country has ratified the charter can make a submission before the commission. That's the first opportunity. No barriers, nothing else. Secondly, more and more countries are ratifying the Maputo Protocol, and human rights lawyers can therefore bring communication before the commission using the protocol. And you'll know why when I just give you a quick highlight right after this. And then thirdly is that the commission can be used as a backdoor to refer cases to the court. And so this, again, is an opportunity that can be used. So why I've emphasized on the Maputo Protocol is, please allow me just to very quickly, but not to lose the interpreters on this, provide the normative value of the Maputo Protocol. First, it's a first instrument that delineates the different types of discrimination against women, and addresses the special measures that are needed to address it. By that, in terms of remedies, by that, allow me to explain. The CEDAW committee has provided in great detail in its general comments, I think 34, 33, in great detail, special measures, programs, and structures that are to be put in place to ensure women come to equal level as their counterparts. These measures can be put for purposes of political representation, they can be put for purposes of education, they can be put in place where women have for years been discriminated upon. So whereas constitutions fail to make these provisions, whereas domestic legislation fail to put these provisions, where countries have ratified the Maputo Protocol and it forms part of the countries, then they are obligated to put in place such measures. And so people have an opportunity to litigate, to compel states, or they actually file communications to compel states to put in place special measures as a remedy to address discrimination of women. My second point is with regards to HIV and AIDS. Again, the first instrument to speak to this, recognizing that women are the highest percentage or disproportionately affected by infection on HIV and AIDS. But it recognizes other distinct issues such as domestic violence, calling for countries to actually put in place domestic legislation addressing domestic violence. So you see the illustration giving you communications can be brought before the commission if there's failure for it to be addressed locally with regards to putting in place legislative protections on domestic violence. It addresses even issues to do with polygamy. Can be contentious because people might say that they've chosen and they've got their right to do so. It addresses that. It addresses medical abortion. It addresses a whole host of issues previously not addressed. I also saw, my point number 3, I saw in the questions someone asking how to distinguish between contrast our African values versus the protocols and so on. Here is where, I'm excited about the protocol and its potential to litigate on this, just if only to get better clarity and to put our governments on the back foot on this to ensure the rights of women are realized. The protocol is specific where vagueness previously prevailed when it came to African values. It says that, it clarifies that it's only positive African values. And it doesn't just leave it as positive. It says positive means that they're based on the following principles. If it has to be principles of equality, 1, peace, 2, freedom, 3, dignity, justice, 5, solidarity, and democracy. And it also spells out the scope of social economic rights in greater detail. But so with regards to positive African values, the different values that are being foisted upon women folk in different contexts can be challenged on a myriad of issues from discrimination, but also under the fact that they do not meet the measure or they don't match muster with regards to positive African values. I will just rush through. A necessary implication is that it requires criminalization of rape in marriage, which will again be a step forward. It speaks of corrective and positive measures. I've already talked to that. It provides structural remedies. I've already talked about that. It speaks of electoral quotas for women. I've talked about that. It talks about illiteracy and education. And so if I'm to just quickly move us to this, let me just do the what do you call it, not redundant, but the redundant thing of just listing the potential of communications that could be brought before the commission. It could be on discrimination. It could be on the right to dignity, which even it speaks to integrity and security of person. It is the first instrument that speaks very specifically and criminalizes harmful practices such as female genital mutilation and child marriage. It speaks on marriage very distinctly and clearly, including what I was saying about providing for criminalization of rape within the context of marriage. It speaks of divorce. It speaks of separation and annulment. It talks about access to justice. It speaks about political participation, peace, protection in armed conflict, right to education, economic, social rights, sexual and reproductive health and rights. It's not done. Right to food security, adequate housing within the context of ECOSOC rights, right to positive cultural context. I've already talked about that and explained the 6 different elements that qualify that. Right to healthy, sustainable environment, sustainable development, widow rights, inheritance, special protection for elderly women, women with disability, women in distress. And so opportunities abound. Just because we are out of time, and you can quite easily get how to file a complaint before the commission, I will just simply say this: who can file? We've said anyone whose country has ratified the charter. The person can be natural or legal, meaning the legal person, such as NGOs. You could see for the first case, Equality Now was one of those that filed the case or filed the complaint before the commission. So just know the door is open in that regard. Key points: the author can be the victim, and if the author is a victim and wants anonymity, they need to say that from the beginning. There's the exhaustion of local remedies rule. We don't escape that just because this is a commission, but then there are exceptions to this rule, and all of you know about exhaustion of local remedies. That is, give the country or your government the first bite at the cherry, and when they fail is when then the matter comes before the commission. And so if the victims are indigent, then you can come straight. If the complaints involve serious or massive violations, again, you can bring it directly. If domestic legislation outs the jurisdiction of the national court, you could bring it there. For example, you know where it says some countries do not address ECOSOC rights at all whatsoever, then you could escape and bring the matter before the commission if the rights claimed are not guaranteed by domestic laws. And you could see I have case law to support the exceptions, and so on and so forth. With regards to compatibility, a communication must allege just the basics, that a right has been violated by a state party, and it must be based on facts that occurred in the territory of that state party or in an area that that state party controls. So in violation of the African Charter or the Maputo Protocol. And I explained the compatibility in greater detail. Just again, simply, as I told you, Article 55 of the Charter explains some of these things. The communication should not have any disparaging or insulting language. It can be turned back. And disparaging and insulting language could be something as simple like in the El Samni case, the complainant said that the officials are corrupt. And so the communication can be put out. So make your case. Don't judge your case already by yourself. Just make your submission and allow the commission to make its decision on the same. And it cannot simply be based on media. And this is just to ensure the veracity of the information that is being brought before the commission. And so you could bring affidavits, video evidence, documentation from specialists, and so on and so forth. And so it needn't just be based on media. It has to be submitted very much like the court, although the court, I realize, has opened this door wide open, but it has to be done within a reasonable time. And specific description of what reasonable is, the commission it hasn't quite defined that, but I mean, as soon as you've either fulfilled the exhaustion of local remedies rule, or you feel that you're exempted, then submit the matter before the commission. Then the usual lispendence rules or ratio, if a matter has been decided before another equivalent body, or is before an equivalent body, then it cannot be had before the commission. And so the checklist is, as you can see on your screens, and it's found in Article 56. Time is really not on my side, so that maybe just the seizure, once the commission receives it, the process of consideration of a communication begins. The Secretariat will register the complaint with a reference number and send it and acknowledge it, send an acknowledgement to you as the author, and will distribute it to the members of the African Commission. And so in the event that there's not sufficient information, you can provide further information. I feel that some of this information is quickly and easily available to you. And so I will just highlight and allow us then to dwell with what might not be as easily available. So once the African Commission has decided to be seized of your communication, it notifies this respondent state and the complainant of its decision. And the complainant must then present arguments on the admissibility of the complaints within 2 months. Just a quick note is that there's provisional or interim measures that if the violation is continuing, then the African Commission can grant interim relief or provisional measures to prevent irreparable harm being visited to the victim. So if you're complaining about a violation that is still ongoing, you can obtain an interim measure. Again, to note that I've already talked about evidence. The onus of proof has not yet articulated a clear, the African Commission has not yet articulated a clear standard with regards to onus of proof, but it's however indicated that the complainant should provide concrete and convincing evidence. And this is in line with, for example, when the requirement was that media evidence only would not suffice. And just to note also that at any stage of the examination of the communication, the Commission may on its own initiative or at the request of any of the parties facilitate a settlement of an issue between the parties. So there are numerous opportunities. Just the second last part of the presentation is please identify systemic issues, and so that you're filing a complaint before the Commission that will address an issue that individual's case, but it would have greater impact if such issue is addressing a class of people, and so that one case provides relief in fixing the system or the structure or the government structure or policy or law. Please, again, identify the laws that one would be relying on, in this case, the Maputo Protocol and the African Charter, but also looking at the general comments of CEDAW, decisions of the Inter-American System that will present a persuasion before the Commission and allow the decision of the Commission to provide a broad range of remedies for the victim. We've talked about evidence. I needn't say more. Again, relevant jurisprudence, you now know that you have 2 cases or 2 communications before the Commission that have been positively decided on, which could lend weight to your work. Remember, establishing of state obligation, for instance, in the case of harmful practices, even if the actors or the perpetrators are not the state has a responsibility, and that obligation can be built as you develop your case. Parties to the suit, there's possibility of amicus even before the Commission, would you believe? The forum here will be the Commission. Questions of jurisdiction, we've talked about that. Admissibility, we've talked about that. And remedies, we've talked about that. I wish to highlight that we need an out-of-court engagement strategy, and this is largely media to ensure that the matter is out in the public. Let me just quickly is that with such an open door, in recent times, there's a slight political pushback with regard to the Commission and the decisions of the Commission. And currently the discourse that is playing is whether or not decisions of the Commission require ratification by the political class or the political body of the African Union. I leave that to you to determine in your feedback or in your question. I thank you, and I'm open for questions.
Thank you, Judith. Let me take off my video feed because I think my network is a bit weak. So thank you so much, Judy. Unfortunately, you know, we ran out of time, but the good thing is that we should be able to share your presentation with the participants, and they should be able to keep the presentation and use it as reference. I'll quickly take some questions and allow you to catch your breath while participants are making their verbal contributions. And I think that probably, depending on the nature of the questions, we will combine now the last session of the general discussion, because we are really at the tail end of the program today. Probably start off with Eric as Judy is catching her breath. We'll start off with Eric responding to questions and comments that came through in the meantime as Judy was presenting. And then later on, Judy will come back to respond to the questions that the participant would have raised. So Jessica, I recognize you. Please, can you make your contribution now? Your hand has been up for a long time. Jessica. Jessica, are you there? All right. Let me go to Siaka Koulibaly. Please make your contribution. Siaka Koulibaly, would you like to make your contribution now, please?
Okay.
Yes.
Oui, bonjour, merci. Alors, je suis Siaka Koulibaly, Burkina Faso. Je voudrais remercier la Cour et la coalition pour cette formation très importante qui permet de rendre cette juridiction continentale beaucoup moins virtuelle qu'elle jusqu'à présent. Je pense que plusieurs interventions ont permis de voir que beaucoup d'Africains ne sont même pas informés de l'existence ni des possibilités qui sont offertes pour la protection des droits humains en général. Le commentaire que je voudrais faire, c'est sur un peu la conception même des modules. Et je pense que les modules sont très bien. Ils ont également été très bien présentés par les auteurs. À mon avis, ce qui manque quelque peu, c'est l'existence des cas pratiques qui auraient permis de reprendre tout ce qui a été dit dans les présentations théoriques là, de façon concrète, permettant aux participants de saisir la vraie portée des différentes dispositions de la charte, de la Cour et du règlement. Je dis ça parce que même si les participants sont des juristes de formation, peut-être que beaucoup n'évoluent pas dans des contextes qui leur permettent d'avoir des contacts avec le monde juridictionnel, ce qui est le cas de la Cour africaine des droits de l'homme et des peuples. Donc, nous sommes des défenseurs des droits humains qui avons des contacts fréquents avec le monde de la justice, mais lorsqu'il y a un nouvel instrument, un nouveau mécanisme comme la Cour africaine se présente, il faut utiliser une méthodologie qui soit imparable à la fin, de sorte que les participants ressortent très renforcés, très outillés par les possibilités qui existent au niveau de la Cour africaine des droits de l'homme et des peuples. Je vous remercie.
Thank you, Mr. Koulibaly. I have Femi. Your hand is up. Would you like to make a contribution now?
Can you hear me, please?
Yes, I can hear you. Please go ahead.
Thank you. Let me also thank the coalition for this opportunity and to commend all the resource persons. My question goes to Judy. Her presentation is quite elaborate, exhaustive. My question has to do with the technicality as far as Nigeria is concerned. I don't know whether this particular technicality is applicable in filing communications before the commission or filing applications before the court. The technicality is that in filing human rights lawsuits, they have to be individual lawsuits. Class action is not allowed, at least at the beginning. Cases may be consolidated later after they have been filed individually, but not filing joint class suit on human rights issues. I do not know whether this technicality applies before the commission as well as before the court. Thanks very much.
Thank you for your contribution, Femi. Flaviana, please, would you like to make a contribution now? Flaviana.
Hello?
Yes, please go
Yes.
ahead.
Thank you so much. I would like first to comment on the presenters for the well-researched and a very good presentation, which really, we have really been educated by that. I have two questions to Judy. The number one questions, apart from, I just saw at the last bullet was talking about case selection, and she was trying to list some criteria which are taking into account to ensure that they are building a gender case. Apart from that, I just want to know if there is a deliberate effort of ensuring that there is gender mainstreaming in all aspects of human rights, particular aspects of commission's activities from the beginning to the end, if there is a deliberate effort of trying to mainstream gender in every aspect of the commission's work. And then the second question is about the issue of, I asked in the other session, I also want to know, because I know the recommendations which are given by the African commissions also, Judy, I know Judy has talked about the way they ensure, they make sure, they try to make some effort to ensure that the recommendations are binding and trying to be enforced. I want to know to what extent they have managed to ensure that the government, they implement the recommendations which are being issued by the commissions, and what is being done to ensure that if the government doesn't comply with the recommendation, what effort has been done so far to ensure that the government is trying to obey or try to implement this kind of recommendation, because in most cases we have seen that the government, they don't take action on that recommendations. So I just want to know the effort which has been put in by the commission to ensure that the recommendations are taken into account. Thank you so much. Otherwise, good presentations. I really appreciate for that. Thank you, Mr. Moderator.
Thank you, Flaviana, for your contribution. Mandy Asabga. Mandy, would you like to make a contribution now?
This presentation has been so illuminating. Quite a well-researched paper, and I'm really glad I'm part of this. Now, I would like first of all request for precedence on communications before the court or the commission. If we can have that, that would, I mean, go a long way in helping us to, make some complaints to the commission. That is one. And then the other one, I'm looking at the issue of matters that come before the court or the commission in terms of enforcement of judgments, I mean, are there any sanctions for non-compliant states? And then, what are those things that the courts can do to ensure that the beneficiaries of these judgments get compensated, within a reasonable time? Because I've known of cases that have been done over the years, and up till now, no form of compensation whatsoever has been given to the victims. So what is that extra, what's that extra mile they can go to ensure that the victims get benefit for the judgment that they have gotten, from the court? Yeah, thank you. Judy, thank you very much. I really appreciate you guys. Wonderful, wonderful. All the resource persons have done a very great job. Thank you, guys.
Thank you, Mandy, for your contribution. Combo, would you like to make a contribution now? Combo, Alain? Combo, are you there? All right. Let me put to the presenter some questions and comments that are in the chat box, so that when we put these questions to the speakers, they may react to them, the questions and comments, as their final words in this general discussion, and then thereafter we'll then wrap up the session for today. One of the questions says, how can the court and the commission overcome the different religious and cultural considerations that limit even this equality of rights in practice? How can the court and the commission overcome the different religious and cultural considerations that limit even this equality of rights in practice? So the participant goes on to say, if I give you an example, in Senegal, in matters of inheritance, Islamic law is used by the people, even though Republican laws may consider them discriminatory. So in Senegal, he's saying inheritance is under Islamic law, is applicable to people, even though Republican laws may consider them to be discriminatory. So what is the court strategy for this kind of point of contention in society? What is the court strategy for this kind of point of contention in society? So you have Islamic laws on inheritance being discriminatory in the face of Republican laws. So what is the court strategy to deal with this contention in society? That's my understanding of the question. But for presenters, can read these questions in the chat box for a more clearer understanding. And then the next one is from Ruth. I think the knowledge on the importance of gender and women's rights. I think the knowledge on the importance of gender and women's rights is there. The gap is whether there is positive change in attitude and norms. So knowledge on the importance of gender and women's rights is there. The gap is whether there is positive change in attitude and norms. One cannot effectively litigate something they don't believe in. So you see now the issue of knowledge being important, but the knowledge is actually there, or its importance on gender and women's rights is there. But the gap that the participant is referring to is whether there's positive change in attitude and norms. One cannot effectively litigate something they don't believe in. Probably linking to what Eric said earlier on, to say in some cases, those who are supposed to assist others harbor some patriarchal attitudes or beliefs in them, thereby making it difficult for them to fully advocate for the rights of women or equality in general. Then Ndaima says, I congratulate the exhibitor for his brilliant presentation. I think the presenter for his brilliant presentation. And he makes one observation, which is that the presenter did not refer to people with disabilities in his presentation. So isn't this category of persons part of gender concept? So the issue of persons with disabilities and gender, you know, in some discussions we hear that if you're a woman and you're with disabilities, then you're facing multiple levels of discrimination based on having a disability and also being a woman or a girl. So the presenter, so the participant, I think, wants to have a comment here to say what are the thoughts of the presenter as far as disabilities is concerned in this discussion on gender issues. Then another question from Kone says, I'm a member of the Association of Women Lawyers in Cote d'Ivoire, and we work a lot on the gender issue. And we have many men who complain that when it comes to gender issue, they have noticed that only women are concerned, whereas the gender issue is not related to sex, and that they too men must be taken into account. So I think in their endeavors to push for gender equality or to advocate women's rights, they've seen that there are many men who complain that they have noticed that only women are concerned, whereas the gender issue is not related to sex, and that they too, the men, must be taken into account. Then again from Cote d'Ivoire, I think translated by our IT people, our support team, as an NGO, how can we, as an association of women's lawyers who are struggling enormously on the issue of gender, seize the court if your country, that is Cote d'Ivoire, has just withdrawn the right of individuals and NGOs to seize it? So in other words, it's a follow-up question to what we discussed briefly last time, to say some countries have withdrawn from the competence of the African court to deal with complaints from individuals and non-governmental organizations, the 34-6 declaration. How can they now seize the court's jurisdiction in view of the fact that Cote d'Ivoire is withdrawn? So it's an issue of access to the court, access to the commission. You know, I think the presenters will be able to give us quick answers to this. Robinson Makundi says, how effective is African court toward engaging in gender issues vis-a-vis cultural anthropology to some member states, e.g. child marriage and FGM? The question of human rights standards versus cultural standards at the national level, that conflict, you know, how effective is the African court toward engaging these gender issues in the face of, I think, cultural diversity? And some examples, child marriage and FGM. Those are some of the questions that have been put across. And I think that, yes, these are the questions that have been put across. I think the presenters can now respond to these questions and comments. Eric probably could go first, and then Judy, as she is still catching her breath, she will come later and wind up the conversation. So we have already passed our time by 8 minutes, so we don't want this to stretch more than 10 minutes. Eric, you have the floor, please. Thank you.
Thank you very much, Dr. Tarisai. Let me start with questions which were raised earlier. Tormo raised a question about the level of acceptability of the protocol establishing the court. And I think the last question is also about it. This is really a question about universality of human rights and the cultural relativity. I think really there is a need for the court and the commission to look deeply into this issue, because of it is hindering the enjoyment of human rights on the continent. But for now, the approach of the court has been just to look at the state commitment and the level of compliance. In this communication, in this case against Mali, application is 046/2016. Really, the State Council raised that issue. He was saying that in the Malian culture, the way marriage is concluded is not the way the Maputo Protocol provide for. But the court escaped the question. The court did not handle the issue as such. And I think I agree with you that is a question the court has to focus on. And the commission also has to focus on that too. Then there was a question about the role the court has played in addressing issues affecting LGBTI people. Unfortunately for now, I think the only case that raised those issues was a request for an advisory opinion. But the applicant didn't raise the question directly. They were asking the court to give an opinion whether or not the African Union can reverse a decision of the Commission. The matter preceding that application was about the African Commission asking the Commission to amend its activity report and to withdraw some passages, especially a passage granting observer status to the Coalition of African Lesbians. But the court didn't delve into the merits of the case. The court said that the applicant did not have a standing to bring a request for advisory opinion. So the court didn't have a personal jurisdiction to entertain the case. There was another case about the age of marriage. It was also an advisory opinion. There was a application 001/2016. It was brought by many, I think 5 NGOs, women's rights. But again, it was about Article 6 of the Maputo Protocol, what it entails as obligation for state to eliminate child marriage. But once again, the court didn't address the merit of the case because the court said it doesn't have, it can't deal with the issue as the applicant didn't have the standing to bring the case before the court. And the issue that arises from all the application for advisory opinion is that NGOs cannot bring a request for advisory opinion before the African court, because they have to meet 2 requirements: being an African organization, which is easy to meet, but to be an organization recognized by the African Union. And the court has interpreted this provision to mean, this requirement to mean, that you must have an observer status with the African Union Commission or a memorandum of understanding with the African Union Commission. And no NGO has been able to fulfill those 2 requirements. What about other questions? So I think Siaka Kulibari talked about cases that have been issued by the court. Unfortunately, there are not many on gender issues. And then the most, I think, important case is the one I touched on, application 046/2016 against Mali. But as you listened to me, I think, throughout my presentation, so throughout the answer to questions, the court didn't delve into the merits of advisory requests. And I don't know if Judy may know any other case dealing with the gender issue on the merits. Personally, I don't know any other issue, but any other case dealing with this issue on the merit. But the principles that the court applied dealing with other issues can also apply in this particular to address gender issues. The court applied the principle of equality and non-discrimination, the protection of the family, and so on. So the court applies various norms which can be used to address gender issues. I think the question about how people from Cote d'Ivoire can take us to the court has been answered. And what else? And then the issue about women with disability, whether disability is a gender issue too. It can be a gender issue in the sense that can make women more vulnerable. We have come across of cases in which women who have some physical disabilities were branded as witches. They know what it entails. She may be a woman accused of being a witch. She can be assaulted. She can even be killed. So this can be a in fact, all the issue may think that they may be neutral. They may be gender issues because they make women more vulnerable because they are already vulnerable in the society. So whenever there is another problem adding to the existing problem, it may become a gender issue because women were already vulnerable. They should also repeat that men as well as women can be victims of gender violence or discrimination. And I think NGOs and also lawyers should be open to assist men whenever they come to you alleging to have been a victim of gender discrimination or whenever they bring gender issues to your attention. I think I have covered all the questions. Thank you so much for your attention.
Thank you, Eric. Judy, do you want to share your views and on some of the questions posed to the presenters, as well as maybe just the comments made, whether you agree with them or just your reaction as we wrap up now? Thank you.
Okay.
Judy.
Thanks, Dr. Tarisai. So I'll start with Femi. He talked about a technicality, not being able to bring a class action suit. So it's not a problem. When you talk about a systemic issue, you can bring a case for one person, but which case is representative of the issues. So for instance, when we filed the case for Nagash, not the case, but we filed the complaint for Nagash, the government of Ethiopia was found responsible for failing to protect women and girls from those violations. And so the judgment, whilst it responded to that one girl, responded to a systemic issue. because this was actually a common practice in Ethiopia at the time, and the response was the same. And similarly, but in a different forum, for the ECOWAS court, when we filed the case where they banned pregnant girls from attending school, when the ban was, whilst we filed the case, we had to have specific names. And so we had 6 girls as the face of the case. But the judgment resulted in the lifting of the ban, so everybody benefited. So whilst you cannot have the opportunity to file a class action, you can have an opportunity to undertake a strategic litigation, which is a case that you bring before the African court, or the complaint which you bring before the African Commission. So you can bring an individual case, but you can also bring a case that is representative of a deeper issue. And then Flaviana, you were asking, apart from case selection, deliberate effort to ensure all aspects of human rights and activities work. In response to you is that the Commission has you remember the other elements that we spoke about. There's the protection, there's the promotion, there's of rights, and under those, the other mechanisms that the Commission can use. We have a special rapporteur on the rights of women, whose work is to ensure that the rights of women are protected, who undertakes promotional activities, who supports the interpretation and expansion of specific norms, especially when those norms are unclear or people find them to be shall we say, controversial, and so they can be explained and determined properly, and therefore can be taken up well. There's the missions that, promotional missions that the Commission can undertake. They've done so. Send an invitation to country, come into that country, speak to the leaders within that country, including the attorneys general and so on and so forth, to ensure some of these things are taken up. And even decisions from the Commission itself can make recommendations, as we saw for the uptake of the Maputo Protocol, for instance, as being part of the framework to be taken in a country. So the communication is one angle, but there are other angles through which the Commission can push towards that. And then there was a question about enforcement, actually both by you, Flaviana, but also by Mandy, about enforcement of decisions. I think Eric has spoken about the court, enforcement of judgments. The court itself is its own mechanism of enforcement. And so once the court has issued a decision, it can follow up on the level of implementation of that particular decision and can call back a state to report on how far they are with regards to implementation. Not so the Commission, they don't have that power. However, for the 2 cases, for instance, I can speak specifically with regard to the cases against Ethiopia. The Commission has been very keen and followed up on the matter, either through the rapporteur and on the issue. And also, unfortunately, because it's a quasi-judicial body, sometimes the onus with regards to enforcement lies with the NGO or with the person who's filed the case. And so therefore a need for an advocacy / media strategy every time you submit. And so in the checklist that I'll share my presentation on the checklist, there is a need to develop an advocacy and media strategy that runs concurrent to your communication, so that whilst you're still respectful of the communication process and not making it public where it is yet to be so, one can get the general public to track with them with regard to any case or communication or complaint that has been brought. And therefore the public pressure can be brought to bear then on a state to respond appropriately. Then there's a question with regards to inheritance and a conflict of laws. 17, Article 17 of the Maputo Protocol, the one that I spoke about, the 6 elements that qualify a positive cultural context. And then also the laws overriding or superseding the certain principles of non-discrimination and so on that override or supersede that. And so what happens is that if one being a Muslim or one being a traditional practitioner doesn't want to be subjected to that and has not submitted themselves to the process of Islamic Sharia law, but have submitted themselves to the laws of the land and have failed to get justice, are being discriminated upon based on it, then that person can file before the Commission a complaint or a communication that there's been discrimination visited on them based on that and allow determination to be found, or can even challenge that. Because, for example, female genital mutilation is claimed by some countries, including Mali, to be a religious practice. And then it's challenged before the court and can be challenged before the commission. And so those are good opportunities that are most welcome to bring communication. Change in norms, I agree. There's need for us to change norms, and this can be done by promotional visits, by engagement, but also addressing what's the heart of this, which is gender equality, which helps me address the next question by Kone. How I like to address this question is this, in terms of what about the men? What about the boys? Are we not considering them gender as a social construct? It's not sex. What about them? How I want to address this question is simply this way. Rights are not 10 balls in a bucket, that if women get 7 balls, then men only have 3 to contend with. On the contrary, everybody has their right. And if, for instance, I'm alive and you're alive, if you kill me, you don't get more days. So what has happened is that women have had hurdles and barriers consistently to their buckets, to their rights. And what this is all about is removing those hurdles and barriers and holes to enable women to get there. So if men have hurdles and barriers to their rights, then they should address that, as opposed to putting barriers in the way of women. It would mean that we are all blind, and that doesn't make for a good society, or we're all not educated, or we're all brutalized, we're all raped, then we're all fair and equal, and that doesn't work. Let everybody just remove whatever challenges and barriers exist and allow us to then meet at the top in a society that is equal and fair. And I think that would be the way to go. People with disability, absolutely. I mentioned them in the list. Article 23 of the Maputo Protocol speaks specifically to women with disability. It also speaks to the intersectionality of the challenges and places them in the vulnerable group, because then they face the discrimination in totality, including the vulnerability that this disability places on them. We've got someone speaking about the Association of Women Lawyers, how then they can file a suit. Remember, the commission can make a referral of your case before the court. Consider that as a route, and see how that could possibly be undertaken. And finally, there's a question with regards to human rights standards versus international standards, child marriage and FGM. And I've already said the Maputo Protocol has been very clear with, and the first instrument really to speak about child marriage and FGM in the light that they should speak about it. I think it's important for people to understand the harm that these practices actually visit on women, on girls, and therefore not seek to assuage them or make them mild, but interpret them against the light of the African Charter and the Maputo Protocol. And I think we should then be on safe ground. That's it. Thanks, Dr. Tarisai.
Thank you, Judy and Eric, for your remarks, the final remarks, I should say. Thank you once again for your presentation. I'm advised that this presentation will be available to all the participants for keeps as part of the package of this training. You need to go away with something for future reference purposes. So these presentations will be availed to you by the Secretariat of the African Court Coalition, whom I would like to thank for convening this third installment of our online training for legal practitioners and CSOs on the engagement with the African Court and the African Commission on Human and People's Rights. But you could hear even from our conversation that our presenters have been talking about the third human rights body, which is the African Committee of Experts on the Rights and Welfare of the Child. But look, there's no discrimination. There's no discrimination. We're not discriminating against the Children's Committee. As you know, the African Court Coalition is there to ensure that there is effectiveness in the court's work. But it is important that we rope in the African Commission as we've done now. And I'm sure going forward, there will be an opportunity to rope in even the African Committee of Experts on the Rights and Welfare of the Child, because it's one body. It's one system, rather. The African Human Rights System is one system made up of those different bodies but they all work together to make each other effective. So I cannot wait for the final installment of our training, which is going to be there on the 16th of October. Is it this Friday? I hope so. On the implementation mechanisms at national and regional level. We also look at the effective tools to follow up on implementation of decisions of the African Court and the African Commission. So as part of this training, and it's one of the clear objectives of the training, was to ensure that participants go away with the knowledge on how to participate in the implementation. Remember, implementation of decisions takes place at the national level. Violations take place at the national level. Adjudication can take place elsewhere, maybe in Arusha or in the Gambia before these bodies, or in Addis Ababa. But the implementation of those recommendations or decisions does not take place there. It takes place at the national level. And as lawyers, as law associations, as media, as CSOs, we participate in the implementation process at the national level. If we don't participate, it will never be effective. So the whole essence of engaging these treaty bodies is to ensure that we litigate before them. We also do advocacy before them. But after litigation, the decisions and recommendations of these bodies should be fully and genuinely implemented at the national level. Otherwise, with no implementation, there is no need for us to waste time and resources approaching these bodies. We must ensure that decisions and judgments of our bodies are implemented. It's through implementation that the lives of our people who suffered violations will be changed. That's why I'm saying I cannot wait for the 4th module, because it wraps up the whole discussion. It is the logic of litigation. It is the logic of adjudication of human rights violations. So I really look forward to seeing you there. But for now, let me thank again the African Court Coalition and the Rawale Institute for convening this online training. And the participants, of course, we have been with us from the first session, or first module rather, at the beginning of this month. I look forward to seeing you again on the 16th of October for our final module, the same time, 12 p.m. Arusha time. And hopefully we are going to end the training on a high note. So I wish you a good day or a good evening, a good afternoon where you are. You know, Africa is diversified even in terms of time zones. So I hope you enjoy the rest of the day, and definitely look forward to seeing you on Friday as we wrap up our online training. Thank you and goodbye.